Grateful, and it's an honor to be here today, especially I know a lot about Mr. Mathis's career, and I'm just grateful that he's sitting here. This is a day that in so many ways our ancestors are looking back and with pride. I was almost laughed, I have to be honest with you, because I was in a Foreign Relations Committee. I didn't get to watch the first part, but I heard that driving records became a part of it. And I laughed with my staff that I have a rap sheet now, probably much longer than than the witnesses. But then I thought, and I want you to answer this as much as it is going to be anecdotal. But I grew up in Bergen County, New Jersey. My family was the first black family to move in. And all my high school friends, when we started driving, started noticing that I was pulled over quite a few more times than they were. And we all knew what it was about, especially back in those days, coming over from Washington Heights. If you were driving over the GW Bridge, and my brother and I used to think if we were black, we just prepare for being pulled over. And sometimes I was pulled over for going 3 miles over the speed limit, for something cracked or that looked awry on my car, and it put me in a position where I'm much more likely to get more tickets than my white peers, my best friends. And I'm curious, is that the case with your experience as well, growing up as a young man driving while black?
I want to turn the microphone there.
Thank you, Senator Booker, for that question. I take responsibility for my actions. I don't want to blame anything or anyone else for what I did. I take complete responsibility for what I did and the circumstances that I placed myself in. That's what I'll say about that.
Sir, that is a great answer, and in many ways, the humility and respect that I think your character speaks to, and I want to just express my appreciation for that. I'd like to also, Chairman, I got a chance to witness on this committee the change on the blue slip policies, and it really was difficult for Senator Menendez and I when it came to our state. Before the Trump administration, the Senate in modern times had never confirmed a judicial nominee over the objections of both home state senators. The Congressional Research Service didn't find a single time it happened, and you could count on one hand the number of times the Senate confirmed a judicial nominee, even when one home state senator had objected. The Trump administration and the Senate Republicans didn't just break the tradition, they really smashed it. It was 17 Court of Appeals judges who lacked blue slips from their home state senators, 17. One of those was in our state. It was Paul Matey, who now sits on the Third Circuit of my hometown in Newark. Senator Menendez and I received nothing that could even be considered meaningful consultation. At no point before Mr. Matey's nomination did the White House offer to set up a meeting between us and the judge, the now judge. The White House never even mentioned anyone else they were considering besides Mr. Matey. It was obvious he was the only person they would consider. And I made repeated requests for a meeting with Mr. Matey during the confirmation process, and the administration wouldn't even let me meet with him. And that meeting only eventually happened after Mr. Matey had already been voted out of this committee, days before his final vote. And so by contrast, even though it was the Trump administration and my colleagues on the other side of the aisle who shattered this tradition, I understand that the Biden administration has in fact engaged in meaningful outreach and consultation with home state senators about the nomination. I understand what it means when you represent a community and you're not being engaged in the process. I felt the coldness and the hardness of that. But it's one thing to shatter that, what the Trump administration did, and then ask for it to go back to the way it used to be. This is a great nominee. And I've gone deep in reading about your background and your record, and I'm blown away by the pro bono commitment that you have. And I'd like to, just my final question really, if you could tell the committee more about why you've chosen the kind of representations that you've done for individuals that often lack resources. Why is that an important value? In your view, why is ensuring that full representation for every criminal defendant, no matter how despicable sounding the charges are, why did you find it in your career when you didn't have to do these things so important to do that kind of pro bono work?
Thank you, Senator, for that question. That work is really important to me because when I was growing up, didn't have much. So when you get to a position where you can help others that don't have much, that's vitally important for me, and that's part of the reason why I take court-appointed cases and do pro bono work. Is that ability to help others that aren't in the best situations, and also as it relates to the criminal work, is the Sixth Amendment allows for individuals to have attorneys, even if they can't afford it. And I believe, based on my experience, I'm capable of helping others in that capacity.
And you're aware that tradition goes back to the Boston Massacre and the British soldiers that were represented then by one of our founding fathers, correct?
That's correct.
And you believe it so deeply, in many ways driven by your own experiences. You mentioned that you grew up with very little.
That's correct.
And this idea that the ideals of justice in this country demand that everyone has equal access to justice and equal access to justice, and the key of representation is very important to that.
There's no question about that. When you think about equal access to justice, everyone should be treated the same when they're in court. Whether you're the government or indigent defendant, whether you're an individual or a company, everyone just wants to be treated fairly, that their case is considered impartially, and everyone is treated fairly. Again, it doesn't mean you'll get a decision that's in your favor, but the key is that you felt like you've been heard. You have your opportunity to be heard, and you were treated fairly.
Well, I just want to say in conclusion, I love your state. My mom went to Fisk University. I have family roots there. I've served with a number of senators from your state, including the current ones. I actually have a lot of respect for. When they speak, I listen. You have great House members from that state, and on both sides of the aisle, people who love the community and serve it with honor and distinction. And I'm looking forward to voting for you on the floor, because I think that you will represent the best of what the great state of Tennessee is on the federal judiciary, on the circuit court. So thank you.
Thank you.
Thank you very much, Senator Cruz.
Thank you, Mr. Chairman. Mr. Mathis, welcome.
Thank you.
And I've got to say, I think you have a legitimate beef with the White House, because the Biden White House has placed you in a very difficult situation. The Biden White House's conduct in putting forth your nomination and in disregarding the views of the senators from your home state has placed you in an almost impossible situation. That's not your fault, but it is President Biden's. You're familiar with Article 2 of the Constitution?
Yes, Senator.
What does Article 2 of the Constitution lay out?
Article 2 lays out the executive powers of the presidency.
And among them is the power to appoint judges. Now, Article 2 does not give the president unfettered authority to appoint any judge he or she chooses and have that be the end of the process, does it?
No, the Article 2 does say that it must be advice and consent from the Senate.
And let me ask you, Mr. Mathis, why is it that the framers of the Constitution required, before any judge becomes a judge, the advice and consent of the Senate?
Thank you. Thank you, Senator, for that question. Checks and balances is something that the framers worked into the Constitution, so the executive gets to nominate, but a different branch of the government must sort of do the confirmation.
Now, as some of my Democratic colleagues have pointed out in the previous Senate, we halted the process of the blue slip for Court of Appeals judges. Court of Appeals judges cover multiple states. But that did not mean that in the previous Senate we stopped consultation with home state senators. It meant home state senators didn't have an absolute veto over a Court of Appeals nominee, as home state senators continue to do with district judges. But the Biden White House's behavior in your nomination is fundamentally different. Let me ask you, when did you hear from the White House that they intended to nominate you?
I heard from the White House that they intended to nominate me. I believe it was 3 or 4 days before the nomination. And I was nominated on November the 17th. So I believe it was the Friday before or that Monday.
When did you first begin discussions with the White House about the possibility of being a federal judge?
First began those discussions, I believe it was late May or early June, if I'm not mistaken.
So late May, early June, we're looking at 6-7 months that have passed. Throughout all that time, the White House did not have a conversation with the 2 senators from Tennessee. The White House did not seek their consultation. The White House did not give them an opportunity to meet with you. The White House did not give them an opportunity to assess your qualifications. Instead, the White House just barreled right ahead, ignoring, and that's not a word I use lightly, ignoring the senators elected by the voters of Tennessee. Let me ask you something. Are you familiar with Judge Camille Mcmullen?
Thank you, Senator. Yes, I am familiar with Judge Camille Mcmullen.
Have you had the chance to argue before Judge McMullen?
Senator, I have not argued before Judge McMullen.
So my understanding of Judge McMullen is that she served 14 years in the Tennessee Court of Appeals. She is an African-American woman. She was appointed to the Court of Appeals by a Democratic governor. Is all of that right?
All that is accurate. I believe she was appointed it was either 2007 or 2008.
In your judgment, is Judge McMullen qualified to be a federal Court of Appeals judge?
Thank you, Senator, for that question. Judge McMullen is a great judge. I never practiced with her, but I'm sure she was a great lawyer. That's what I can say about her. I think she's a great person, great judge, and I'm sure she was a great lawyer.
Is there anything about Judge McMullen's record that you know about that would lead someone to think that she was some secret, stealth, right-wing choice?
Senator, I'm not familiar with her record beyond her being a judge and a lawyer. I don't know anything about her record. Again, I believe she's a great judge, and I'm sure she was a great lawyer.
So my understanding is the senators from Tennessee suggested Judge McMullen, an African-American woman who had 14 years service in the State Court of Appeals, who's well-respected, who's qualified, suggested, and who was appointed by a Democrat, it's not a Republican. And the White House, as far as we know, did not give consideration to that suggestion, did not give weight to that suggestion, but instead barreled ahead and said, we're going to pick the judge, and you pesky senators can go jump in a lake. Yes, Ms. Mathis, I'm sorry the Biden White House has done this to you, because in terms of how this institution operates, there's no senator that wants to see a White House treating home state senators the way the Biden White House has with this nomination. The chairman may not admit it to you, but he doesn't want to see a Republican president making an appointment from the state of Illinois for the Court of Appeals without bothering to talk to him, without bothering to listen to him, without giving him any input whatsoever. That's the position the Biden White House has put you in, and that is very unfortunate.
Before recognizing Senator Whitehouse virtually, I have asked, because it came up this morning, I asked the White House for an official statement as to what they did do in relation to your nomination. And I want to read it into the record. I'm glad Senator Blackburn is here, and I want her to comment. She may disagree with some part of it. I want her to have the right to comment afterwards. The White House counsel's office reached out to the office of Senators Blackburn and Hagerty on June 4th, 2021, to discuss the Sixth Circuit vacancy. The White House communicated that Andre Mathis was a candidate that they were very interested in, but requested the senators' views and any additional candidates they might propose. That was June 4th, 2021. On June 17th, counsels for both Senators Blackburn and Hagerty met with you, Andre Mathis. On July the 6th of last year, the White House received an email from Jeff Parrish, Senator Blackburn's state counsel, with a carbon copy to Senator Hagerty's chief counsel, The email confirms that counsels were able to meet with Mr. Mathis at the White House suggestion, and merely notes that staffers enjoyed their conversation with Mr. Mathis. The email did not take a position on his candidacy. In the same email, the Tennessee senators proposed that the White House consider Judge Camille Mcmullen for the position. Just to correct the record, the White House reviewed Judge McMullen's background and interviewed her in the intervening months. The Tennessee senators never reached out to indicate that they wished to meet with you personally, Andre Mathis, at any time. The senators also never communicated that they had any reservations about your nomination. The only written communication the White House received from the Tennessee senators about Mr. Mathis between June 2021 and November 2021 was the email from Senator Blackburn's state counsel confirming they had met with you. In November 2021, the White House reached out to Senators Blackburn and Hagerty's office again to let them know the president planned to nominate you. We indicated that we appreciated, the White House says, indicated they appreciated their recommendation of Judge McMullen and noted that they'd given her due consideration. I make that matter of record, and I put as a postscript there that I have already conceded that we should have sent blue slips to you, Senator Blackburn, and to Senator Hagerty, which is normal course of business. For some reason that was done. I accept full responsibility for that, and I apologize to you. And let me now turn it over to Senator Blackburn if you would like to amend or make any comment about that statement.
Thank you, Mr. Chairman. The statement that the White House has submitted, as I said earlier when I spoke this morning, it is incorrect about their outreach. After they indicated that the indication that state staff had met with Mr. Mathis, Senator Hagerty and I had opened the process for those that wanted to apply to be a circuit judge. Mr. Mathis did not apply. We did settle with Judge McMullen, and she's highly qualified and highly regarded. Now, following that process in the intervening months, the White House had no further outreach. The White House did not offer for us to meet with Mr. Mathis. And in conversations with someone from his law firm, I know that he had been encouraged to reach out. I do not know who advised him to not reach out for a conversation, knowing that we wanted to have a conversation. It is important that, and you know this very well, Mr. Chairman, because when it came to your federal district courts and when it came to the Seventh Circuit nominees during the Trump administration, that administration sent to you a list of people to choose from. And you sent back your list. And then they selected from your list.
Well,
now that is advice and consent. You were a part of that entire process.
Senator, I was part of it, but we were negotiating back and forth.
Okay, that's fine. You were a part of the negotiation. But see, what has happened here, the disrespect that has been shown to Senator Hagerty and to me by this White House by not involving us in that process, the disrespect to the people of Tennessee for the president's team to just say, here's our guy, and we are just going to bulldoze this through. Don't worry about it. You're going to have a tough hearing. It's going to be kind of a process, but then you're there for life. Now, does that make him a political appointee to sign off on the Biden agenda? Is that what this is about? But you know as well as I do, this is not a traditional, ordinary process, and it is unfortunate. So there are inaccuracies in what the White House has said. I know they told another member of this committee yesterday, oh, we've reached out to them several times. They reached out at 4:55 yesterday afternoon.
That was That's on me. That's not on them.
Well, whomever it is on, it is inappropriate that that is the way that it has been handled. The people
Senator-
of the state of Tennessee deserve to be heard through their elected representatives in this process.
Thank you, Senator.
Mr. Chairman?
I'll recognize you next. The only thing I would add, it was not my experience with the Trump administration that Senator Booker was talking about when he said 17 times the same thing happened to Democratic senators under President Trump as you are suggesting happened to you under President Biden. Senator Cruz.
Mr. Chairman, my understanding of the Trump administration is their practice was consistent with how you described their practice with you, which is that they engaged in consultation with Democratic senators, but they did not have an absolute veto.
I might have been an exception, but Senator Booker suggests that in his case, neither he nor Senator Menendez had anything like that relationship with the Trump White House.
You know, I know that the Trump administration in states where particularly you had 2 Democratic senators, and that occurs where you have state senators from an opposing party, that the process was slower, and there were times where they were frustrated and ultimately did not go with the senator's choice. But my understanding is that the consultation was commonplace. I just wanted to ask a clarification, and I appreciated that you apologized to the senators from Tennessee for the blue slip, and I was not here for the early part of the hearing, so you may have clarified this and I didn't hear it. But my understanding is that the blue slip was sent to the Tennessee senators 6 days ago after the hearing had been noticed, that it was emailed on January 6th, but that the blue slip was backdated to November 22nd. And I wanted to ask, is that understanding correct? And if so, why would it have been backdated?
I don't know. And I accept full responsibility. That isn't what I do every morning, is send out emails and blue slips, but I accept full responsibility as chairman. All right. Senator Whitehouse.
Thank you, Chairman. Welcome, Mr. Mathis. Good to be with you. I was in the room briefly earlier, but I'm coming to you electronically from my office right now. I wanted to take a moment to put into perspective that with respect to consultation, Republican senators may believe that they were regularly consulted on circuit court appointees, and they may well have been. But immediately before Senator Cruz made the assertion that the Trump administration consulted with everyone, Senator Booker had said that he'd had no consultation at all, despite requests. And I think that experience of Senator Booker's was far more the practice in the Trump White House. I say that having had a good experience with the Trump White House with respect to our district court nominee, but I believe we had that good experience with our district court nominee because then Chairman Graham protected the blue slip for district court nominee. So the White House knew that it had to deal with Senator Reid and with myself on that nomination. Where the blue slip has been disabled and lost, then there's no consequence when the White House disregards the concerns of a local senator. And as I pointed out before, not only does that take away the leverage that senators have in this conversation and allow them to be, to use a word that's been used already, bulldozed, but it also, in effect, blows up the bipartisan recommendation process that many states have, because there's no point going through that whole exercise if the senators from the state can't enforce their committee's recommendation to the White House with a blue slip. And finally, as we saw in one example in California, it doesn't even mean that the allocation of seats to states survive. My only experience, for the record, was with the Puerto Rico seat in the First Circuit. Puerto Rico does not have a senator. And my recollection was that simple contact about First Circuit appointees would be made to senators about the Puerto Rico so-called seat, senators in the First Circuit, and we had no discussion or consultation whatsoever about that. Again, it wasn't the Rhode Island seat, it was the Puerto Rico seat. It's a little bit of an unusual thing because with Puerto Rico having no senator. The other thing I wanted to flag is that I think the nominee has been subject to some unfair criticism of his record. He's an extremely experienced trial lawyer who's handled cases in multiple states. He's been involved in a great deal of appellate litigation, including arguing cases in courts of appeal, briefing in the Sixth Circuit, helping organize and plan appellate strategy to the Sixth Circuit, and so forth. And I just note that when Justin Walker came through this committee for a position on the DC Circuit, he had been 6 months on the district court, 6 months. He was less than 10 years out of law school. On his way to the district court, he had never tried a case. Never. And the American Bar Association gave him a not qualified rating. And every Republican supported him for the DC Circuit. Naomi Rao had virtually no litigation experience. She had participated in an amicus brief and had handled 2 international arbitration cases, but had never tried a case. And she too went on to the DC Circuit. And when now Justice Barrett went on to the Seventh Circuit, she'd been in private practice for 2 years. She'd been an associate counsel in 1 case. She had never served as sole or chief counsel in any case, and she had helped with briefing in 1 appellate case in the Second Circuit. By comparison to Judge Walker, Judge Rao, and Justice Barrett, I would hazard that Mr. Mathis has more courtroom, trial, and appellate experience than all of them added together. So I would just take what little remains of my time to ask Mr. Mathis if he could say a little bit about not only the trials that he's done, but also some of the preparatory work, motion practice, depositions, everything else that goes on as you get ready for trial and appeal.
Thank you, Senator, for that question. Generally, when I'm representing a client, I'm representing the client from the beginning of the representation all the way through the case ends. So that's all the way through the trial court proceedings, from discovery to the motion practice. And if it makes it through motion practice to a trial, I'm trying the case. So I'm involved in the strategy from the beginning all the way through the trial. And if there happens to be an appeal, I'm involved in the appeal as well. And again, most of the appeals that I've handled, I've been the lead drafter, and I've argued 10 appellate matters.
Thank you,
Thank you, Chairman.
Thanks, Senator Whitehouse. Let me say 2 things, if I can, for the good of the order. To our people who've gathered here, the families and other nominees and friends and public at large, you may wonder why we're spending so much time talking about this inside baseball issue, about blue slips. Mr. Mathis, it is your good fortune to be the first circuit court nominee before us, I believe, since President Biden was elected from a state with 2 Republican senators. So we're kind of testing the waters here about what we're experiencing and what we hope to experience in the future. And so we're not just carping on a trifle. These really get down to basic fundamental questions about the selection process for lifetime appointments to the highest courts in the land. So this is not just political bickering. We are trying, and I believe Senator Kennedy made a positive contribution to the conversation earlier. We're trying to find some common ground, and I hope we can, ultimately. The only other point I would raise, and then recognizing Senator Hawley, is that each one of these nominees goes before the American Bar Association, which sets up a committee which surveys the attorneys and judges in the jurisdictions that they practice law and asks some fundamental questions about temperament, knowledge, experience, trustworthiness, on and on. And then they give us a grade. The grade that was given to Mr. Mathis is the highest possible, unanimously well qualified. So when people are raising questions about his experience and background, his peers and those who appeared before him and those who appeared before have come down with their unanimously well-qualified rating. Senator Hawley, I believe you're next.
Thank you, Mr. Chairman, and congratulations, Mr. Mathis, on your nomination. I want to start by adding my voice in support of Senator Blackburn and Senator Haggerty, and saying that I hope that the process has been followed in this nomination will never be the process again. But I also want to point out that this seems to be a more systemic issue in the sense that Senator Sullivan, who's not a member of this committee, as the chairman knows, Senator Sullivan, Alaska, has been unable to meet with any Ninth Circuit nominee who would be judging cases from his state for the entire past year. He has asked repeatedly to sit down with Ninth Circuit nominees. He's not a member of this committee, doesn't have the benefit of being able to ask questions here before we vote on them. He'd like to meet with them. And as of December, for months on end, he was unable to just ask questions of the nominees, and for that reason has been voting no on nominees he might otherwise be willing to support or at least to consider. And I just don't understand it. I don't understand why it's not possible, why this White House is denying senators the ability to meet with nominees, engaging in basic consultation. I don't get it. I guess it's just a no-holds-barred, burn-all-before-you strategy. But I have to say, I think it's one that's going to backfire, and I think it's unfortunate. Mr. Mathis, that really doesn't have anything to do with you personally, so I'm sorry that you've had to sit through all of this because it's really not about you, but I agree with the chairman to the extent that I think these are important issues and I hope ones that we can get resolved. But let me ask you some questions about your own record. Let me ask you about a 2007 law review article. Were you in 2007? Had you graduated? Is that the year you graduated from law school?
That is the year.
So in this law review article, maybe you wrote it while you were in law school. I'm not sure about the timing, so maybe you remember. But in any event, I want to ask you about it. You argued there that the Supreme Court ought to create a freestanding actual innocence claim when it comes to federal habeas petitions, which, as I understand it, would allow a convicted defendant, to be able to relitigate his case at any time if he alleges that he has enough evidence to prove his innocence. Have I got that right? Am I rehearsing your argument right there?
Thank you for that question, Senator. That article I wrote while I was in law school, it was published in 2007. I think I was still in law school when it was published. And the case that I was writing about was House v. Bell, which is a case that originated in Tennessee, which is why it was of interest to me. And there was two issues that the Supreme Court took up in that particular case. I don't recall what the two issues were, but the court found in Mr. House's favor on one of the issues and therefore did not address the second issue.
And so do you continue to think when it comes to the federal habeas procedure and creating a freestanding actual innocence claim, do you think do you still advocate that position? Is that something that you think is still a good idea?
Senator, since I wrote that article and I've been practicing, I haven't written academic articles since that time.
Probably wise.
I'm sorry.
I said probably wise, but
yeah,
go ahead.
I've litigated a number of cases and hadn't litigated issues related to the freestanding innocence issue. So I hadn't litigated that issue and haven't advocated for that particular claim since I was in law school.
Well, I ask because I have concerns about that. That would be a very significant departure in federal habeas law, which would create, I think, a very significant new set of challenges for prosecutors, for those trying to bring these folks to justice. And so it concerns me. But it sounds like this is not something that you've continued to advocate. Let me ask you in my time remaining here about some of these questions of experience that you've been getting. And you just said, I want to be sure I understand. You've argued 10 different appellate cases. Those are in federal court or state court? Or
Those were in state court.
And then how many circuit courts of appeals, federal courts of appeals, have you litigated in?
I've litigated in the Sixth Circuit.
Okay, just the Sixth Circuit? And you've not argued in the Sixth Circuit, is that right?
I have not argued in the Sixth Circuit.
How many appellate cases have you handled altogether in the Sixth or anywhere else, if you had to put a number on it?
23 to completion. I have one currently pending before the Sixth Circuit.
Okay. And to those who would say and have asked you about your record as an attorney, I know you've had a court kick back a filing because you didn't disclose what you're supposed to disclose. You mislabeled a brief for rehearing, had a court kick it back to you, and that, every attorney makes mistakes. But what would you say to those who say, well, his work sometimes a little sloppy, doesn't seem like there's a record here of courts sort of having issues with some of what the filings that he's given. What's your response to that?
Thank you, Senator, for that question. In any case that I handle, especially before appellate courts, I try to abide by the rules. You mentioned issues that were kicked back, one where I didn't do the PDF correctly, things of that nature. Those have happened. Of course, I correct those issues promptly, and none of those have prejudiced my clients, and there's been no issues with the briefs that I filed.
Yeah, fair enough. Great. Thank you, Mr. Mathis. Thanks for being here. Thank you, Mr. Chairman.
Senator Hawley, if I could respond to a statement that you made earlier about Senator Sullivan, Republican senator from Alaska. He came to me and he believed that since Alaska is fairly unique in the Ninth Circuit, that he wanted to meet with the nominees for the Ninth Circuit. I checked into it, and there is a mixed record as to whether nominees make themselves available to individual senators. But I thought his was a legitimate and good faith effort to, he said, I've only got 2 or 3 cases relating to Alaska. I want to at least tell him what they are. Senator Murkowski agreed with him. I believed it was a good faith request, and I went to the White House, and he did meet with 2 Ninth Circuit nominees as a result of it. I'll offer the same support to any member of the committee who is not in the interest of delaying anything, but in genuine interest of knowing where they stand on cases that are relevant to their states.
Thank you for that, Mr. Chairman. I'm glad you intervened in that respect. And I think your last point is an important one, that Senator Sullivan wasn't trying to delay anything, but and he's not a member of the committee. He didn't have the ability to ask questions. But I just regret, make my point again, I regret that you might remember that Senator Sullivan went to the floor and blocked a number of nominees and voted no. And he had to do all of that in order to get the attention of the White House. And I thank you for your good offices. But, it really shouldn't come to that. And I see this situation as similar. That Senator Blackburn, Senator Hagerty have had to say, listen, this is really wrong, and point out that they haven't been afforded basic consultation rights. And that really shouldn't be necessary. But thank you for your good offices in that circumstance.
You're welcome. I believe Senator Padilla is waiting to join us virtually. Senator, are you there?
Yes. Thank you, Mr. Chairman. And I, too, similar to Senator Whitehouse, was in person earlier, but joining virtually from my office here in Hart. And I won't be as repetitive. I know several of my colleagues have already raised the issue, addressed the concern that Senator Blackburn raised earlier about the blue slip process. Won't rehash that, but I do want to speak to something else that Senator Blackburn said. She mentioned the blue slip process, and then proceeded to talk about it allegedly as a breach of constitutional norms, which to me is a greater issue, a greater concern. If our Republican colleagues want to have a conversation about breaching of constitutional norms when there was very little challenge to so many breaches under the prior administration, I would welcome that opportunity if it led to improved practices and procedures for the functioning of the Senate. But I do believe that is a conversation for another day. Let's keep the focus today on Judge Mathis, who by everything I can gather is very much qualified and experienced, and has earned the consideration in this hearing today. Mr. Mathis, you spent 15 years practicing law in state and federal courts, in civil, criminal, and administrative proceedings. You've tried 19 cases to final decision. That number might have increased from a response to a recent question. Argued 10 appeals. Please update that number if that's inaccurate. Not counting the hundreds of cases that you've worked on, but don't get to the point of trial or appeal. You were also appointed by the Tennessee Superior Court to serve on the Disciplinary Hearing Committee for the State Board of Professional Responsibility. considering this wide range and depth of experience that you've had, can you tell us which might have best prepared you to become a federal judge?
Thank you, Senator, for that question. I think the experience that best prepared me to be a federal judge is the appellate work I've done, as well as the work I've done in the trial courts. Obviously, when you're on the when you're at the Sixth Circuit, you're reviewing matters from the trial court. So I have a great basis of knowledge, having litigated more than 100 cases in federal court through resolution at various points, at the motion to dismiss phase, summary judgment phase, after trial. So having those experiences, I think, prepares me very well. But also for the cases that I've handled, for most of the issues, I've litigated both sides. When we talk about employment cases, I've represented individuals, but I've also represented companies. And the same for the other type of cases that I handle. So most of the issues I've litigated on both sides, and I practice in a broad range of areas.
Great. Somewhat of a follow-up. You have briefed and argued numerous appeals, but significant experience in the trial courts, which you have, can also be a crucial asset to an appellate lawyer or judge. How will your work in the trial courts inform your service as an appellate judge?
Thank you, Senator, for that question. Of course, the Court of Appeals in most cases is hearing alleged errors from the trial court. So one thing I have a lot of experience with is whether those errors have been properly preserved, objections and things of that nature. And that really determines the standard of review that the Sixth Circuit can consider when the case makes it that far. So I believe having that experience in trial court will inform my decision-making process if I'm fortunate enough to be confirmed to the Sixth Circuit.
Okay. Thank you for responses. Thank you for your willingness to serve. Mr. Chairman, thank you.
Thank you, Senator Padilla. There are no other senators seeking recognition. And I would like to close with one last request. The Bar Association may have found you unanimously well qualified. This chair of this committee finds your children unanimously well behaved. And we wish that all of us as members of the Senate could be as well behaved. Please introduce them again before you leave.
Absolutely. I'm happy to introduce them. My son, Andre Mathis Jr., and my daughter, McKenna Mathis, and of course, their great mother, Dr. Victoria Mathis.
And your mom and dad. Thank you, Mr. Mathis. We appreciate your testimony today. You may receive some written questions. We hope you'll respond to them in a timely way. Thank you very much. With that, we'll move to our second panel. I'd ask for everybody's patience for a moment as we do a setup here. It just takes a minute. We have 5 nominees who will be seated at the witness table, and we're going to hear from them. Once they're in place, we'll ask them to be sworn in and start their testimony. Don't get too comfortable. I'm going to administer an oath when everyone's in place. If you please raise your right hand, do you affirm the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? Let the record show that all 5 nominees, thank goodness, answered in the affirmative. And we'll start with Ms. Clark. You have 5 minutes for an opening statement, and then other nominees will follow, and questions will follow from senators. Ms. Clark.
Thank you, Chair Durbin. I'd like to thank you and Ranking Member Grassley for convening this hearing, and all members of this committee for considering my nomination. I'd also like to thank Senator Schumer for his kind words and his recommendation of me to the President. And I would like to thank President Biden for this incredible honor. With me here today, I have my amazing husband, Malik Thompson, my wonderful mother, Lynn Clark, who traveled here from Winston-Salem, North Carolina, and one of my closest friends since law school, Sarah Byram. My loving father, Dr. Raymond Clark, and the light of my life, my son, Kari, are close by as well. I'd also like to recognize several family members who couldn't be with me here today, including my brother, Dr. Philip Clark, and his family, my sister-in-law, Judge Amina Thompson, and her family, and my mother-in-law, Dr. Condi Bourne. There are many family members who have passed away that I'd also like to recognize: my late father-in-law, Dr. Sherwood Thompson, my grandfather, Dr. Byron Branker, my grandparents, Audrey and Charles Clark, and my adopted grandparents, Stretch and Gladys Jenkins. I'd also like to thank my colleagues at the New York Attorney General's Office for their support, with a special thank you to the incredibly talented and dedicated attorneys and staff of the Civil Rights Bureau. I'd also like to thank my former colleagues, friends, aunts, uncles, cousins, who all supported me throughout this process and throughout my career. Lastly, I wouldn't be here today without my late grandmother, Gloria Branker, and all that I learned from her. She spent her career as a secretary working alongside American heroes like Justice Thurgood Marshall and Judge Constance Baker Motley. She always wanted one of her grandchildren to pursue law, and as her only granddaughter, born on her birthday 60 years later, it was only fitting that it would be me. One of my last memories with her was showing her my law school graduation program. I knew that she was proud of me then, and I know she would be incredibly proud of me today. Thank you.
Thank you very much. And now we have Mr. Gonzalez. Please proceed.
Good afternoon, Mr. Chairman. I want to thank you, Ranking Member Grassley, and the entire committee for the opportunity to appear before you today. I would also like to thank President Biden for the honor of this nomination. I am also grateful to Senator Schumer for his kind words of introduction and for his and Senator Gillibrand's support throughout this process. I also want to congratulate my fellow nominees. I know they feel as honored as I do to be here today. On a more personal note, let me introduce and thank my wife, Amy, for her love, steadfast support, and boundless patience. Also here with me today are my daughters, Isabella and Liliana. As proud as I am of this nomination, nothing makes me prouder than being their dad. I'd also like to acknowledge my wife's family in Chicago, and especially my father-in-law, Rick Jaskulka. Rick welcomed me into his family with a generosity of spirit and love that I will always cherish. While there are too many former colleagues and friends to thank individually, I do want to say thank you to my colleagues at Deckert, a law firm filled with smart, hardworking, and caring people. Finally, I'm sorry that neither of my parents is still with us. They would have been so proud to share this moment with me. My parents and I came to the U.S. from Cuba in 1969. They made that journey not for themselves, but because they wanted to bring me to a place where it was possible to thrive. The person I am today is the result of the love and sacrifices my parents made for me. As a result of this experience, I've always felt a great sense of debt to this country for opening so many doors of opportunity for me. If I am fortunate enough to be confirmed, I will strive to repay that debt every day by upholding the great traditions of the federal bench. Thank you again, and I look forward to answering any questions the committee may have.
Thank you very much, Mr. Gonzalez. And now, Judge Slaughter.
Good afternoon, everyone. Thank you, Chairman Durbin, Ranking Member Grassley, and all of the senators and their staff for holding this confirmation hearing today. Thank you to President Biden for the honor and privilege to be nominated. Thank you to my home state senators, Senator Feinstein and Senator Padilla, as well as their respective judicial selection committees. I am truly grateful for your support. I also wanted to congratulate each of my fellow nominees. It is truly an honor and very humbling to be here today. I want to acknowledge and thank my parents. To my father, Fred L. Slaughter, and my mother, K.V. Slaughter, you are both heroes of mine. The values you taught me are with me every moment. I want to thank my wife and 3 children. To my wife, Nicole, thank you for making each moment better than the last. To my children, Mila, Alina, and Dirk, I could not be prouder or happier. I wanted to thank all the people who helped me on my journey to this room today. To all the dedicated teachers and professors, thank you for helping so many people on a daily basis. From my time working as an attorney at the Los Angeles City Attorney's Office and the United States Attorney's Offices for the Districts of Arizona, Central District of California, and District of Oregon, I wanted to thank all the individuals I had the opportunity to work with, including colleagues, opposing counsel, court staff, and judicial officers. As a judge, I want to thank my judicial colleagues on the Orange County Superior Court, as well as the entire court family, including administrators, bailiffs, court clerks, court staff, attorneys, and stakeholders. Thank you to the members of the committee again. I am grateful to be here, and I welcome your questions.
Thanks,
Thank you,
Judge.
everyone.
Ms. Franklin?
Chairman Durbin, I want to thank you and Ranking Member Grassley for making this hearing possible, and I want to thank all the members of this committee for your consideration and your time. I am honored to have been nominated by the President to serve as chair of the Privacy and Civil Liberties Oversight Board. I also want to thank my family for their continuing encouragement and support. I am grateful that my husband, Jonathan, our daughter, Stephanie, and my mother-in-law, Barbara, are all able to be here with me today. Our son, Noah, and my parents are sending their love and support from Texas and New York. Words cannot express how much I appreciate everything they all have done for me. I have long believed in the importance of the Privacy and Civil Liberties Oversight Board's mission, and I advocated for its establishment as an independent agency as far back as 2006. After the PCLOB came into existence as an independent agency in 2012, I had the privilege of serving as its first executive director, and I worked to further its mission to review counterterrorism programs to ensure that there is an appropriate balance between national security and privacy and civil liberties. If I am fortunate enough to be confirmed, I would welcome the opportunity as chair to serve and carry forward the agency's critical role in conducting oversight over and providing advice regarding the operation of federal counterterrorism activities. With the rapid development of new and emerging technologies, as well as the continually evolving nature of the threats posed by terrorism, the importance of the Privacy and Civil Liberties Oversight Board's role continues to increase. My career has also involved working for several non-governmental organizations, addressing a wide variety of legal and policy issues involving national security and privacy and civil liberties. My work has included advocating in favor of measures to expand protections for individual rights, and I've also demonstrated my ability to work productively with people representing a wide range of views and perspectives. If I am confirmed to serve as chair of the Privacy and Civil Liberties Oversight Board, I would work with my fellow board members and the agency's staff to conduct in-depth investigations and assess the facts with an open mind. In addition to conducting oversight and providing advice, the PCLOB's authorizing statute directs the agency to make its reports available to inform the public to the greatest extent possible consistent with protection of classified information and applicable law. Although some of the PCLOB's reports and recommendations must remain classified, I believe that the PCLOB can and should provide accountability through transparency through wherever possible. Thank you for your consideration of my nomination and for your past support of the Privacy and Civil Liberties Oversight Board.
Thank you, Ms. Franklin. Ms. Williams?
Thank you, Chairman Durbin and Ranking Member Grassley, for your consideration and for your time. I'd also like to thank President Biden for nominating me, and to the other senators on the committee and to their staffs for their courtesy and time in meeting with me. I want to take a moment. I'd also like to thank those who supported me, especially the many current and former career Department of Justice officials with whom I served, and my terrific co-clerks. I want to take a moment to introduce my family. In a life filled with blessings, they are truly the greatest, and I thank God every day for them. My wonderful husband, John, is here, as are my two children, Caroline, who is 10, and Jamie, who is 6. We'll have video evidence that they're missing school today for a good reason. A few years ago, after my first confirmation hearing, I went downstairs and I found my daughter playing with her Barbies. And there was one Barbie sitting in front of a line of other Barbies. And I asked my daughter what was going on, and she said, she's having a job interview. This is her Senate confirmation hearing. And I tried to explain to her that not every job interview required a Senate hearing, but now I'm pretty sure she doesn't believe me. I also want to thank my parents, Judith and Arnold, who are watching online, and my sister, Lori, and her husband, Matt, as well as my in-laws, Marcia and Lowell. My parents set an example for me in every way possible. They are the epitome of what it means to be good and hardworking and kind and decent. They always put my sister and me first, and I owe everything to them. It's an honor to be nominated to be a member of the Privacy and Civil Liberties Oversight Board. The board's mission is to ensure that the federal government's efforts to prevent terrorism are balanced with the need to protect privacy and civil liberties. The board was formed following a recommendation from the 9/11 Commission. The Commission observed that this shift of power and authority to the government that was necessary to counteract terrorism would require an enhanced system of checks and balances to protect the precious liberties that are vital to our way of life. In providing this important check, the board's work is crucially important. If confirmed as a member, I pledge to approach the board's work with an open mind, to exercise independent judgment, and to consider carefully the views of all of the relevant stakeholders, both inside and outside government. As a society, we need to build enduring and bipartisan support for the authorities and institutions that keep us safe. And the best way to do that is through scrupulous protection of privacy and civil liberties. Thank you again for your consideration, and I look forward to your questions.
Thank you, too. And I'm going to ask a few questions and then turn it over to Senator Kennedy, who's kind enough to stay for the second panel. I'm glad he's here. Mr. Gonzalez, what an amazing life story of your family and their travels from Cuba to the United States and the opportunities that have presented themselves to you since. Tell that story, if you will, of what that life experience and family experience has meant to you.
Senator, thank you. As I noted in my opening, the sacrifices that my parents made for me when we came from Cuba, they came with nothing. They had nothing when they arrived here, and they both worked incredibly hard, and that was for me. The immigrant experience is something that is part of me. It is why I feel a great sense of debt to this country for every opportunity. If I'm fortunate enough to be confirmed, I think one of the things that I will enjoy most about the position is the opportunity to preside over citizenship ceremonies. They are an amazing experience to anyone who has witnessed one or has gone through one, and it is a testament to the greatness of this country that there is that opportunity to bring in new citizens on a regular basis to revive the country every day.
You're right. It's one of the highlights of public service to see the smiles on the faces of people from all over the world who finally get to witness the opportunity in America from a personal basis. Those of us who were blessed to be born here never quite made that conscious decision. Thank goodness we had that opportunity given to us, but I couldn't agree with you more. Judge Slaughter, you've done a lot of things in your career. One of them I want to ask you about. It's called the Juvenile Recovery Court and Peer Court. And I wonder if you'd tell me a little bit about what that court is focused on.
Thank you. And those are two separate courts. First, starting with the Juvenile Recovery Court. As part of my nearly 8 years on the Superior Court bench in Orange County, I had the opportunity to serve as the presiding judge on the Juvenile Recovery Court. Now, as that opportunity presented itself, I was presiding along with stakeholders to offer individualized assessments and really looking for solutions for juveniles that were suffering from different challenges, including drug addiction. And what we would try to do on this voluntary program where the individuals would enter would be look for guidance, offer services, meet once a week, really look to the root of the issue, at the same time taking into account accountability. With the peer court, that was kind of a separate part of the juvenile court where it would work with the Constitutional Rights Foundation. And what would happen is that different judicial officers from Orange County would go and meet with different student groups and different juveniles that had been alleged of different offenses. They would admit their guilt, and then they would tell their story to the groups of students who would then evaluate and think about what the best resolution would be. And then the court would then take into account and then make that disposition. Very proud to have worked on those programs.
Interesting. And
thank you.
I look at the problems we have in Chicago with gun violence, for example, and how many young people are involved in these drug gangs and street gangs shooting up one another over slights on the social media or some sort of territorial quest. And I have stopped and think from time to time. They came to the earth in the usual way, and something happened in the course of that early life that put them on track to be gangbangers and oblivious to the realities and the emotions that are involved in many of their actions. So I'm glad to see a novel approach there. Ms. Clark, the issue of civil rights still challenges us, as it has since the very beginning of this republic. What has been your experience working with that issue?
Thank you for the question, Senator. I started my career after clerking for 2 years in federal district court at the Justice Department in the Civil Rights Division. There, I mainly litigated large pattern or practice Fair Housing Act cases across the country. And it was such a great honor to work on Fair Housing Act cases where you're protecting people's rights to live where they want to live and to be free from discrimination. And so it was an honor to do that work. And then I spent time in private practice, also litigating civil rights cases, but also doing commercial cases as well. And now in my current role as the chief of the Civil Rights Bureau, where I enforce federal, state, and local civil rights laws in New York State, it's an honor to serve in that role and to enforce civil rights in New York, and as I did at the Justice Department across the country.
Thank you. I want to ask Ms. Franklin and Ms. Williams, the notion of privacy is an evolving concept. Questions that I'm asked routinely now, and I hear people just volunteering information right and left, really kind of surprise me. You know, I don't think it's, I know when you're getting a $400 haircut, as I do at Supercuts, you should be willing to give them your telephone number, but I basically tell them it's none of their business. They don't need my telephone number to cut my hair. But you get into the privacy issues in your aspirations and your service at a much higher level as to whether or not the government or other sources can have access to a vast amount of information in the name of keeping America safe. That's the reason why we wanted to create your board. And I'd like to have a report, if you will, after some 10 years as to whether progress has been made from each of you.
Thank you, Senator, for that question. And yes, in many ways, the considerations in the national security context and when we're talking about privacy from government are different from in the consumer privacy situation with your haircut. And we do need to have a baseline consumer privacy legislation. But the considerations involved are very similar as well. We have principles like data minimization and retention limits, which are the same across both. I would just mention that in the context of balancing national security and privacy and civil liberties, which is the mission of the Privacy and Civil Liberties Oversight Board, it's important, I think, to recognize that there are not always trade-offs involved, and many steps that our government can take will actually protect both simultaneously. For example, if we take steps to ensure that targeting standards are focused in on obtaining evidence of wrongdoing, that can both make our surveillance programs more effective and better at keeping us safe, as well as avoiding the potential for intrusion on the privacy rights of those who are not involved in wrongdoing.
Thank you. Ms. Williams?
I would agree. And I would just say that I think it was very wise of you and your colleagues to form the Privacy and Civil Liberties Oversight Board after the 9/11 Commission's report, because there's no question that the intelligence community and our national security apparatus is essential to, and their work is essential to keeping us safe. But at the same time, we need oversight. We need checks and balances to make sure that the privacy of U.S. persons is respected and the civil liberties are taken into account so that there's no more intrusion than is necessary.
Thank you. Senator Kennedy, I went a little over, and you're welcome to do the same if you wish.
Thank you, my friend. Congratulations to all of you. I hope to be able to ask each of you some questions, but I do want to stay within my my time limit. Let's start with Ms. Clark. You've been nominated by President Biden, served on the federal district court, which means, of course, that the Court of Appeal is going to review all of your decisions. What is the appellate standard of review for question of fact.
Thank you for the question, Senator. I have not worked on an appeal in my 14 years of experience. I believe that it is reviewed based on abuse of discretion would be this.
No, it's clear error.
Clear error.
As the federal district court judge, you're going to have a lot of discretion on determining facts. How about if somebody appeals one of your decision and they say you made a mistake on the law? What's the appellate standard of review?
Thank you for the question, Senator. Again,
You're
as I mentioned, I have not worked on appeals. If a question like that came before me, I would thoroughly research the law. I understand that there's de novo review, abuse of discretion, and clear error are the different standards.
Okay, but you don't know today the answer.
Thank you for the question, Senator. It would be
welcome.
something that I would need to research further.
Okay. How about a mixed question of fact and law? What's the standard of review on that?
Thank you for the question, Senator. Again, my understanding are that the different levels of review are de novo, abuse of discretion, and clear error.
Well, but that's a question of law and fact is different.
Thank you for the question, Senator.
You're welcome.
Again, in my 14 years of experience, that is not an issue that has confronted me.
Okay. All right. Well, you've been nominated for the Southern District, I think. Is that right?
That is correct.
So you'll see a lot of securities cases?
Yes.
Okay. Tell me what SEC Rule 10b-5 is.
That's a rule that deals with fraud. I have not litigated a securities matter. If I were to confront one, I would thoroughly research Second Circuit and Supreme Court precedent, and I would apply the law to the facts.
Ms. Clark, you've been nominated to the Southern District of New York. It's where most of our securities cases are litigated. And SEC Rule 10b-5 is about as basic as you can get. You want to take another crack at that and tell me what Rule 10b-5 does?
Thank you again for the question, Senator. I regularly confront new issues of law in my practice, and when I do, I thoroughly research the issue.
I know you're going to thoroughly research it, but are you telling me today you don't know what Rule 10b-5 is?
I only have that basic understanding.
Okay. All right. Judge Slaughter, I'm sorry. Let me see here. Judge, you're on the Superior Court of California?
Yes, Senator, thank you.
Right, okay. I see where you've done a lot of speaking about diversity, which I support. Is the Superior Court of California, in your judgment, systemically racist?
Thank you for your question, Senator. That is a question, I think, for policymakers. And as a sitting judge, any matter that could be an impending or pending matter, I cannot answer that.
Let me stop you, Judge, because I've heard this song before. I will stipulate that I don't want to ask how y'all going to rule on a case. I'm just trying to get to know y'all, and I just want your opinion. You're there now, so you've had some experience. Do you think it's systemically racist or not?
Thank you for your question. As a sitting judge, I cannot prejudge issues, and that's the type of issue that could come before me as a judge. But I can't tell you the methodology that I would use, and it'd be similar to the nearly 8 years.
Let me ask you this. You're not going to answer the question, Judge, and I really think that's a mistake. That I know y'all are coached, and I get all that. But I really think it's a mistake not to answer stuff straight up and to hide behind this business of, well, I'll research the law and all that. And I get it. I mean, it happens in Republican administrations too. But our job is to try to get to know you. Do you think that America is mostly good or mostly bad?
Thank you for your question, Senator.
You're welcome.
Mostly good. I'm very proud to be in the greatest country.
Okay, all right. How about you, Counselor Gonzalez?
I have no question that it's mostly good, Senator.
Okay, let me ask Ms. Clark.
I agree, and working for the Department of Justice and representing the United States was a great honor for me. It's mostly good.
Okay, fair enough. Let me ask Ms. Franklin and Ms. Williams a question. Your jurisdiction, let me be sure I get the title correct. Privacy and Civil Liberties Oversight Board. I got that right? Your jurisdiction is pretty broad, isn't it?
So the jurisdiction is broad in some ways in that the board has oversight over counterintelligence programs across the intelligence community with regard to privacy and civil liberties, but it's focused on counterintelligence or it's focused on counterterrorism, not all privacy and civil liberties issues.
Right, okay. I think this is a very important board, but I'm sitting here thinking, we spent 3-4 years with some, not all, I'm going to emphasize that, but some, not all members of our FBI and our Department of Justice selling the Steele dossier. Does that embarrass you?
So Senator, I think, there have been 3 Inspector General reports with regards to some of the things that went on, and I think that the recommendations in them are a good recommendation.
Well, let me ask you this, Ms. Wayne. Do you think the Steele dossier is true?
Well, Senator, I have no basis to believe it's true or either way.
You don't have an opinion?
I mean, I don't have any factual basis to know whether or not I do. From what I've read, it sounds like there's some concerns with the way it was procured.
So I don't understand. Yeah. Do you believe it's true or not true?
So I haven't read the Steele dossier, but from the news reports, it sounds like there may be falsehoods in it. But again, I don't have personal knowledge of it.
Ms. Franklin, do you have an opinion on whether it's true or not true?
I also have not had access to read the dossier, but I can say that I share your concern.
Yeah, but you know if it's true. I want to understand where you're coming from. Do you believe it's true or not true?
I believe that the Inspector General of the Justice Department found significant problems in 3 reports, including 17 significant errors or omissions in the FISA applications regarding Carter Page.
So you believe it's not true?
I believe that the Inspector General found these errors and omissions which are highly concerning.
You agree with the Inspector General?
I find the Inspector General's report very convincing, yes.
Okay. So you don't believe the Steele dossier is true? Why is it so hard for y'all to tell me what you think here? That's pretty basic.
I would turn to the errors and omissions that the Inspector General did point to, which were significant, and I know that Congress has attempted to take steps to address those.
Well, here's what I'm getting at. I mean, I can tell y'all don't want to answer, and I really regret that. I mean, this to me it's not political. It was these allegations that turned out not to be true. It doesn't matter who they were about. But some members of our federal government put the full force and weight of the power of the office behind this dossier. And it didn't matter who they were. And I can't believe you can't agree with me that it's not true. I mean, there have been 3 Inspectors General reports. Where was your agency? Did anybody at your agency stand up and say, wait a minute, Before we make all these allegations on the basis of the Steele dossier, shouldn't we check whether they're true? I mean, FBI Director Comey sold this thing for 5 years. James Clapper was prepared to make a public statement that we're not sure if the dossier is accurate, and Director Comey called him and said, "No, don't say that." Where were you guys at the board? You're supposed to protect civil liberties. You're supposed to protect privacy. Does it matter whose privacy and civil liberties are being infringed? Either one.
So, Senator, I wasn't at the board. I haven't been at the board yet, but I agree with you that that is exactly the role of the Privacy and Civil Liberties Oversight Board, right?
Thank you.
To ensure that the privacy and civil liberties of Americans are taken into account, and to make sure that our intelligence agencies are being completely forthright and truthful with the decision.
Thank you for that. Well, you were there, Ms. Franklin, right? You weren't there?
No, Senator.
Okay, well, when you both get there, I wish you would talk to your colleagues over there. They ought to hide their heads on a bag. They're in charge of protecting American civil liberties and privacy, and it doesn't matter who you are. And they sat there sucking on their teeth like a bump on a log and never said a word. I'm done. Thank you for your indulgence, Mr. Chairman, and I like your haircut.
Haven't had one in a while. Thank you, Senator Kennedy. And I'd just like to say to those who are new to this environment that the mini bar exam that Senator Kennedy gives to many of these witnesses reminds me of my anxiety in law school, where I sat in the last row and slumped down to the point where I have curvature of the spine in the hopes that I wouldn't be called on to answer what 15B is or anything like that. But nevertheless, always entertaining and always well presented. The second objection made by the senator relates to your lack of candor. On this side of the table, we're a different branch of government than what you're aspiring to, by and large. And we have opinions on everything and express them willingly, particularly if it's televised, and very seldom hold back. We know that on the judicial side, the opposite is true. You don't want to put yourself on the record in a situation that may disqualify you from a case, and the frustration Senator Kennedy feels with some of your lack of candor, we felt on the Democratic side with the other administration. It is by nature a reflection on the branches of government being a little different in philosophical approach, to say the least. So before I adjourn today, I want to thank you for cooperation and patience, especially to Caroline and Jamie. Are they still back there? Good. Good job, kids. Questions for the record will be due to the nominees by 5 p.m. on Wednesday, January 19th, and the record remains open until that time to submit letters and similar materials. And with that, this hearing stands adjourned.